action for Mr. Christian Reed or on the matter ending in 0422.
So, Your Honor, we are both.
I only have one file.
There is only one file. Yeah. Yeah.
I need it back up.
Pressing me.
There is. Oh, that one's blank. There is two attorneys because the PD filed a motion to withdraw due to a conflict that was found just in the last couple of days. Yeah.
You write this? Okay. And I don't think I granted it because it's someone going to, I guess, address bond violations.
There is a community corrections report. I was not able to reach Mr. Reed the last couple of days. I know Miss Sack, because the conflict was approved yesterday, and Mac identified Miss Saxon to step in, but it wasn't. The PD is still the attorney of record technically, but Miss Saxon informed me that Mr. Reed changed his number since we last spoke with him, so I have not spoken with him. But it seems like she didn't know that was pending.
I did not know. May I see?
Well, how come you haven't been contacting community correction?
My phone had broke.
Because they've been sending alerts and sirens, Chief.
Yeah, and I was calling off my mom's phone.
On what?
Mom's phone.
On your phone?
My mom's phone.
You talk to anybody?
No, nobody ever answered the phone.
Well, that can't be right.
He indicates they did leave voicemail. Your Honor, could we ask for a moment? And
I think we better, because if that's what he's going to tell me, I think we might have a problem. So I'll pass it, and we get a copy of this. Yeah, I'll pass it. You can see it.
Christian Cook. I'm sorry, Christian Reed.
Okay. What are we doing?
Okay. Your Honor, to address this bond violation, my client's phone broke. He called his mother, who is here, said he was calling a community correction from her phone. Her phone died, and been trying to charge it up to go to her phone provider website to pull up the bill so I can show you proof that on what day and time that they made the attempts to call. He has shown up for every court appearance. Unfortunately, but you know,
I get it, but I don't have any violations because he's not contacted community corrections.
right, he's been complying with the GPS, but they're saying he hasn't contacted since May 26th. And when he called, but unfortunately I can't prove to you because his phone has been broken, which is why PD's office couldn't reach him. And he was calling from mom's phone. That's what I'm trying to get for you. I don't have an iPhone, so I can't charge up her phone to show that. But I personally have left messages with community corrections before, and they don't always respond right away. He's very clear now. I've given him the directive that every time he calls to do a screen print so that we constantly have proof of his outgoing calls.
Charge?
No, I said I do not have an iPhone, so I don't.
No, is it tether charge?
Yeah.
Yes. Because it hasn't been going off, so it has been charged. And they're just saying he hasn't called.
Christian Reed's hearing begins with confusion over his legal representation and a possible conflict involving his public defender. But the focus quickly shifts to his bond conditions. Reed claims his phone broke, forcing him to use his mother's phone to contact community corrections. The judge, however, demands proof of those calls.
No, they're saying they've been sending alerts to the device and he hasn't called.
To call, the way I read it, says sent divert alert saying call agent, not that he was in violation. It's just that his phone was broken so they couldn't reach him. So for the check-in, they use that as a method of reaching out. So it's not that
How come he didn't go down to community corrections?
he called multiple times.
No, I mean,
40.
okay, I'm not getting through to anybody.
No, I understand what you're saying.
Why didn't he go there?
The directive from the GPS was to call in. So he tried calling.
Okay, hold on. You're telling me, tell him to call in. He can't get through to anybody.
And they're not returning his calls.
And so when are you saying he called on mom's phone?
And that's what I'm trying to get for you. But
When did that happen?
The moment that it went off.
In May?
each time he
Every
said,
time. Anytime it make a noise.
but because I know you require proof, that's why I was trying to get the own statements to show you, because the call log that her call log is only going back to Sunday. So we're having to resort to the phone bill in order to try to get the exact date and time that he called.
Phone log only goes back to Sunday?
Actually, I'm looking because there's so much activity. You have to change the setting on your phone in order to keep calls beyond 7 days, 14 days. And I've run into this many times. In my experience in IT, I know that is true, that you literally have to change the setting to hold more than 7 or 14 days.
So when's the last time he called?
I can't give you the exact date and time unless I can get to the phone bill. And we need to charge the.
Well, how long is it going to take to get a phone bill?
Your Honor, I was just in here asking.
Online and get a phone bill.
Her phone is dead, and I even came in.
Okay, well, that's okay.
a-
Somebody's got an iPhone charger around here.
Well, the prosecution.
None of this is making any sense to me.
I asked anybody. I don't have an iPhone and a charger that would fit, so I asked if anybody had an iPhone charger.
Yeah.
And she even tried calling Verizon and got into that loop with trying to get a human.
I see her on her phone right now looking through it, so I'm not sure if charging is the issue.
We've been out asking for a charger, but no, I watched the phone die, and I came in to get my charger.
Right now, then.
She must have a charger now.
Sure, charge it.
Miss Reed. Are you in charger now that has started your phone? Thank you.
What the fuck is
I will say, Your Honor, as you know from your experience, if he was ducking and dodging, he wouldn't show up for every court appearance. And the court would have said that he's compliant.
I'm just trying to figure out, did he follow the instruction?
He said he did, but unfortunately,
He's going to be able to get online and get me a copy of the bill. That's going to show that.
that's what we were in the back doing. And because I know you have these other cases, unless you want to pass, give us time to get back on there. Trust that I will have it for you for end of business.
Well, he's going nowhere unless I have proof that he's called.
Okay.
So I think we're going to do it this way. Mr. Allen, you can take him back. I'm going to remand him back. You get me a phone bill that shows the calls, then I'll release it. If not, then I'm going to set his bond and he's going to sit.
Understood.
I'll pass it.
The judge questions why Reed did not visit community corrections personally after struggling to reach them by phone. His attorney insists he made multiple attempts, but the available call history cannot confirm them. The defense searches for phone records to prove Reed's story, while the judge remains increasingly skeptical about his explanation.
Let's call the case, People State of Michigan versus Christian Reed.
Good afternoon, again, Your Honor. Raymond Joking People.
Good afternoon, again, Your Honor. Christina Saxon for Mr. Reed.
On this matter, I hadn't gotten to, there's a request to adjourn preliminary examination, and I may concede to that. However, there's a bond violation report. The record should reflect that the defendant has not contacted community corrections. It's been regarding his GPS and the like. He in court that he made calls to community corrections. There were some issues to going through the phone and what that was going to show and reveal. But in any event, the court did call community corrections. They have he's instructed to call the agent, which goes through to the computer as well as to the phone. There is no indication of any calls and or messages from the defendant at all.
Your Honor, as stated at the bench when you were kind enough to give us a bench conference, the phone number to the agent was on paper and misplaced. However, he received the number to community corrections by text. But as stated earlier, his phone was broken. So when his GPS tether bellowed out a phone number, he didn't have a pen available. He and his mother, because his phone was broken, Googled Washtenaw County and in an attempt to get to community corrections. I looked at her phone bill, which shows each call. I do see where multiple calls were made to what turned out to be the public defender's office. Unfortunately, a message was left, but they did not return the call saying you have the wrong number. This is who you should call. Furthermore, Your Honor, I would ask, in the face of this potential violation, that because I was just appointed at 2:30 yesterday and just noted bond violation, that you would set this for show cause so that I could get the proper evidence to show that at least attempts were made, albeit to the wrong phone number. He has been compliant every other way. He does have a job. He works at Taco Bell. And again, to my knowledge, this is a matter of a phone call that should have been made, but he now has the number and to lock it in, tattoo, whatever he has to do to not misplace this number again, if the court's not inclined to give us a show cause hearing. As stated in MCR 3.606.
Given that you were just appointed, I will adjourn the preliminary examination to my next date, which is August 18th, 2026, 9 a.m. That is before me. As to the defendant's bond, he has not applied with his condition of bond. Certainly, you may raise by written motion, but I'm satisfied that the defendant had not called community corrections, had not kept in contact with community corrections, despite their attempts to try to contact him. I'm frankly having a hard time believing his story regarding the phone. Certainly could have been that there were calls made. There are no records of any calls made to community corrections, leaving a message to them. As I further had indicated previously, he could have at any given point in time, should it been a problem, he could have gone down to community corrections and straightened the issue out. None of that did the defendant do. So certainly you may raise and bring whatever evidence before the court that you can find, counsel, that may show or have the court draw a different conclusion on it. But at this point, what I'm going to do is the defendant's bond is hereby ordered revoked, defendant's remanded.
Your Honor, I'm going to ask that you allow me to withdraw from this matter then, because as stated on previous case, I will be out of the country on the 18th. And so as to not delay his opportunity, and being that I was just appointed.
Certainly you could file a motion. You did indicate that to me, and I don't want to put it out any further than where I have to put it out to.
Right, I
So
don't,
I'm giving the quickest date possible. If you contact the MAC office, send in a written motion, I will order your withdrawal in new counsel.
okay,
Does that make sense?
it does.
That way. All right. Okay.
Thank you.
Probably fuck.
When the hearing resumes, Community Corrections reports no record of Reed contacting them. His attorney argues that he accidentally called the wrong number and requests another opportunity. The judge remains unconvinced, noting Reed could have visited the office directly. Ultimately, the judge revokes Reed's bond and orders him remanded into custody.